with us?
Yes, Your Honor.
Okay.
Can you hear me?
Thank you very much. Yes, I can hear you. We are on the live stream. All right, ladies and gentlemen, we are on the live stream. The court is calling case number. Let me find Mr. Davis's case number. I'm sorry, I just lost it. Case number Z8058741. Willie Braxton Davis, operating while visibly impaired. This is a motion hearing. This matter was previously adjudicated and by a jury trial, and the sentence was entered by Judge Robinson Garrett. This is a hearing scheduled on a motion for new trial following the imposition of the sentence for 1 year, which was entered January 26th of 2021. Now, I'm reading from the documentation in the record, so I hope that everything is accurate. If not, would someone please correct me? But Mr. Willie Braxton Davis is in the virtual courtroom. Sir, will you please say your name for the record?
Willie Braxton Davis.
Thank you, Mr. Davis. And the attorney representing Mr. Davis is also in the virtual courtroom. Please say your name for the record.
Your Honor, Pauline Soroki, House Counsel.
And Ms. Soroki, your P number one more time, please.
43477.
Thank you. And Ms. Horn, your appearance on behalf of the City of Detroit.
And good morning, Your Honor. Good morning, everyone. Tamika Horn on behalf of the City of Detroit, P70303.
Thank you. And finally, Mr. Gary Bradfield is here from the Probation Department. Mr. Bradfield, would you please enter your appearance for the record?
Good morning, Your Honor. Gary Bradfield on behalf of the Probation Department.
All right. Now, ladies and gentlemen, to begin, let me just say that you can assume that I have read, Mr. Davis, both your motion and the brief filed in support thereof, and the people's response and their brief in support. Is there anything else for the record that was not included in either your motion, Mr. Bradfield, or your response on behalf of the people, Ms. Horn? Otherwise, please don't, in the interest of time, re-argue those things that you put in your motion or your response, because I already know what you said. And both of you, let me compliment you. These were very well drafted documents, made it very clear, which makes it very easy for this court, since I was not here at the time of the litigation, your jury trial, or the sentencing. So I think I've got a pretty accurate picture. I did have the people look up one legal issue for me subsequent to the sentence having been imposed. But otherwise, I'm pretty clear on what happened and what you're asking the court for. Mr. Davis, is there anything else you want to say that isn't in your brief? Sir, I know you're asking for a new trial, and I know the reasons why. Anything that you want to say at this time?
Well, I was
because let me just tell you, Mr. Davis, I know you did. As I said, somebody helped you with this document, and they did a good job. But my hands are tied now. This matter has been adjudicated by jury trial. So I only have a very limited amount of discretion, really almost none, in a case like this. So I have to follow the sentence of the judge who imposed it following a jury trial where the jurors were the triers of fact. So it has to be an error of law at this juncture. Well, just because you say it doesn't make it so. The court
No,
has to
I
look
have
in.
proof.
Okay. What would that proof be, sir?
I never had a chance to put on, I was never had an opportunity to get on to say what really happened under the conditions that I was under. The officer lied on me, didn't break any laws. Jury got it wrong. I didn't have an opportunity to get up and speak on my own behalf. The nurse didn't show up. Things went on with the case. Hello?
Yes, I can hear you. I can hear you.
The state dismissed the case. I don't know how it reached to the point that it did. I had an opportunity to go in front of the state. The officer didn't even show up. She checked my record. I never had a drunk driving record. 68 years old. I don't have any drunk driving. Any of those.
Okay.
Drunk
Thank
driving,
you.
something else? I didn't get, he said, I don't have any drunk driving and then something else?
He said he's 68 years old. Did I hear that correctly? You repeat that for the court reporter. We do have a
Yeah.
court reporter.
Yes.
I'm 68 years old.
Years old, right.
I never had a drunk driving ticket. And as a matter of fact, I went in front of the state. The state dismissed it. He looked at my driving record and the state dismissed it. Can you hear
Okay.
me, Judge?
I can hear you, sir. I can hear you.
Oh.
Let me just
Okay.
say this, Mr. Davis. Again, my discretion at this point is very, very limited. And particularly since you had a jury trial. The jurors are the triers of fact in this case. So the error has to be an error of law. At this juncture, what you're telling me are errors of fact. You did argue a couple of errors, legal errors, but the court finds those not credible under the circumstances. I'm going to let the people respond to what you said. First of all, let me just explain one thing to you that might be confusing. The juror's verdict was to the lesser charge of operating while visibly impaired. Now, visibly impaired doesn't mean you were necessarily drunk. It doesn't mean that. And that is not what was entered as the judgment. So, Madam Prosecutor, did you want to say anything that's not already in your response? Because I can't relitigate the facts. So we are stuck with what we're stuck with. I'm in a box, a tight box.
I'm a diabetic, Judge.
And you know what, Mr. Davis? That may have been relevant had it been argued, but it wasn't. It wasn't.
The attorney, I had ineffective counseling. I never get a chance to and project my situation. Any law.
Madam Prosecutor, any response?
Your Honor, the people will stand on its brief going further. As to any new facts, as the court stated, We will not be litigating any new facts. Even going forward with an appeal, the facts are as they are, and the fact finder in this case was a jury of his peers, and they found him guilty of the lesser charge of visibly impaired. And so those facts stand as they are. And within our brief, as just to just reiterate, this motion was untimely, and there has been no proper appeal filed, Your Honor. So we believe that as far as we should be moving
Then the
forward with,
pandemic,
we should be moving
the
forward.
pandemic was going on.
Mr. Davis, if you would
I'm gonna
give me a
ask you to be
chance to
quiet, Mr.
finish.
Davis, or we're going to mute you, sir, because you can't speak. We do have a court reporter. So even when you're on Zoom and we can see you and hear you, there is a court reporter who is taking contemporaneously a record of everything that's said. She can only hear one person at a time. So we cannot allow more than one person at a time to speak. Otherwise, the record is not coherent. Okay, so I don't want you to argue with the prosecutor. Please don't. It's not helpful. It's not helpful. So let's go forward. And
Thank you, Your Honor.
For purposes of today's motion hearing, for a new trial, defendant's motion for a new trial is denied for the reason that this court does not find the argument regarding ineffective counsel made by the defendant persuasive under these circumstances. Now, I did ask the probation officer here, and Officer Bradfield, I'm going to ask you to speak at this time, because from the record, and again, I'm telling you, I'm limited to the record since I wasn't here. Again, this record, and just so you know, Mr. Davis, the judge who did decide this course has been elevated to the Michigan.
Did the judge freeze?
Oh, no. Can you hear me?
No, I can't.
Ms. Henry? I think Ms. Henry, did I freeze in your system?
No, I think Ms. Henry froze.
Ms. Henry, can we send her a chat?
Froze.
On her to be able to hear me.
There we go.
Thank you. Thank you, Ms. Henry.
No
We're having all kind of technology issues. I did ask Mr. Bradfield, who is the probation officer, to appear, because again, as I looked through the record, I wasn't sure whether you had actually done any of the things that the court had ordered following the entry of your judgment. So, Mr. Bradfield, I would like you at this time to bring the court up to speed on what has happened in the interim since the judgment was entered over a year ago on January 21st. I'm sorry, January 26, 2021. Mr. Bradfield, if you would, please.
Thank you, Judge. Mr. Davis was.
Mr. Bradfield, and I apologize, can you come up a little closer to the mic for me so I can hear you a little better?
Can you hear me?
I can hear you if you keep your voice up nice and loud. Thanks.
Okay. Mr. Davis was sentenced to a 12-month probation January 26th of 2021. Mr. Davis was assessed $695. He was ordered to attend the Victims Impact Panel, ordered to attend Alcohol Highway Safety Level 2, pay all outstanding traffic matters, 10 outpatient treatment, random alcohol and drug testing once a month, shall not use or possess any illegal substance, shall not consume any alcohol. Defendant has a right to appeal this sentence within 21 days. Mr. Davis had a review date of July 26, 2021, which he failed to appear. And there was a show cause hearing that was held November the 17th, 2021, virtually. At that time, the case did proceed. Mr. Davis' probation was continued. Since that time, Mr. Davis has completed the Victims Impact Panel, which was completed on February the 12th, 2022. He went to the Alcohol Highway Safety class on January 29th, 2022. I believe that was the level 1. He was ordered to do level 2. That was on the original order. Mr. Davis had a previous alcohol conviction operating impaired at the 46th District Court, April 5th, 2005, which he pled nolo contendere. He was 6 to 12 months probation in the 46th District Court. So he needed level 2 class. Mr. Davis has been resistant to probation since day 1. That's why he's taking so long to comply with this court. Mr. Davis is in outpatient treatment as of March the 10th, 2022. He's attending 3 sessions currently at Pam's Place Counseling Center in Detroit. Mr. Davis' drug screens have been negative. He's been testing since the last show cause hearing, November of last year. His last drug test was on March the 10th, 2022. It's been negative. He was negative in March. He was negative in February. He was negative in January, December, and November. So Mr. Davis technically was given 12 months probation, which was supposed to expire January of this year. However, Mr. Davis, being Mr. Davis, being resistant to probation, that's why his probation is continuing on today, and it's not been resolved. I'm sorry, Judge, he still owes, he has not paid any money towards the $695. The register of actions now shows he owes $740. He has not paid any money towards his fines and costs. Mr. Davis indicates he's on Social Security, earning $895 a month, and he has failed to show proof of that in writing to probation.
Okay. So, Ms. Soroki, your response to the violation of probation.
Well, I haven't,
Well, is the probation department making any recommendation? Mr. Bradfield?
Judge, we just recommend Mr. Davis continue his probation. He did make some progress, but he's not finished yet. He needs to pay what the court ordered him to pay. He needs to make payments on that. He has not paid anything. It's been over a year now.
Okay.
Yes.
And now, I would say this, and I don't know, Ms. Soroki, what your information is, but I would say, Mr. Davis, you need to pay that money, sir, or you need to show the court that you have special circumstances. No, my turn. You need to show the court that you have some special circumstance. In other words, if you have limited income, then you need to show Mr. Bradfield what your income is. And you can do that. And then maybe they can make a recommendation. Mr. Bradfield said all you told him was your Social Security and you didn't show him anything. So if you think you did.
I got all the paperwork. All the paperwork.
Well, if you have it all together,
I got all my.
Are you willing to show it to him again, Mr. Davis?
Ma'am, yes, ma'am. I got
Okay.
I'm on a fixed income. I'm retired on disability. I told him I got all. I did everything they required me to complete. I have to borrow money to pay the funds, the fees, and everything that they're charging me. So I'm not even guilty. I'm not even guilty, ma'am.
Mr. Davis.
I didn't break no law. I didn't break no law.
Mr. Davis, I'm going to mute you. I have to mute you, sir. If you keep doing that, I'll have to mute you. Mr. Bradfield, if Mr. Davis shows you something that shows you a limited income, the court would not have a problem with your making an adjustment to the amount owed. But I can't just change another judge's sentence, and I won't, without significant, substantial reason to do so. And I haven't heard that. I haven't heard that. And
No,
Mr.
no law.
Davis,
No
Mr.
law.
Okay. Ms. Soroki, did you have anything to say to the court at this time?
No, Your Honor, I asked that my client's probation be continued to allow him to complete the terms and conditions. And I was gonna say, there is no violation at this time, so.
Well, there is in that the things he was ordered to do have not been completed within the time frame. So that is a violation. Are the people
The
asking Mr.
pandemic was
Bradfield
going on,
has not,
ma'am.
Mr. Davis, I'm not gonna say it again. If we were in the building, my officer would have long walked up on you. But now what I'm gonna ask is that the clerk mute your device if I have another interruption. And again, sir, the reason is that we have a transcript being taken. It's as important for the court as it is for you that that transcript be accurate. So Madam Clerk, if there's another interruption when I'm talking or someone else is talking, I'm asking you to mute Mr. Davis. At this time, Mr. Bradfield, I did not hear you ask for a violation. What I did think you asked for was that the probation continue. And do you, Mr. Bradfield, have a request for the time frame for the continuation? How much more time?
Judge, we're asking for a minimum of 3 more months for compliance, maybe sometime in July.
All right. Okay, and what I would like to do, I mean, that doesn't give us much time for a review of that, because really the penalty for non-compliance is to close the matter without improvement and a jail sentence. And that's the penalty. So at this point, the court is going to follow the recommendation and extend the probation period for a period of 3 months at this time. Madam Clerk, what date would that be?
1 moment, Your Honor.
And then I'm going to give an interim review. So I don't want to just let this go for another 3 months without Mr. Davis making progress of
That would
some.
be Thurs- oh, I'm sorry, Your Honor.
So July, what time frame?
July 7th is
Oh.
3 months from today.
It's 3 months. So if we give him a 6-week review, what would that date be? So we're extending probation until July the 1st. And we're going to do an interim review in 6 weeks to make sure that Mr. Davis is on track. Because at this time, I haven't heard any reason to modify anything. And although Mr. Davis did take the level 1 alcohol and highway safety education program, he was ordered to take the level 2. And so he does need to take that level 2 program. Level 1 doesn't substitute for level 2.
6 weeks would be May 19th, Your Honor.
Okay, so we're going to do another review May 19th. Thank you very much. And that'll be a Zoom review in the interim. I want Mr. Bradfield to carefully monitor this and let the court know if there are any issues that are intervening that we need to take notice of. And Mr. Davis, I need you to at least start payment. Even if you're paying.
I don't have any money.
Mr. Bradfield, if you can verify that, let this court know. I don't know if there's any opportunity for any alternative for Mr. Davis. And maybe Mr. Davis is just trying to get the court to find him in contempt or in violation and require a more severe penalty. I'm not trying to do that to you, Mr. Davis, but it sounds like you trying to make the court do that. A
Ma'am, I'm
jury
only get
found you
$800
guilty.
and some dollars a month. I
Okay,
live,
well,
I'm a diabetic, I have my medication, I'm managed to get these fees, I do what I can, I pay, I don't have it, I've been retired since 95. Money.
okay. I want you to show that documentation, please, to Mr. Bradfield. That's
I'll
all
do
I'm
it.
asking you to do.
Down to Mr. Bradfield. I try to cooperate all
Are
I
you-
can. I'm a sick man. I've been going to the programs, I've been going.
Madam Clerk,
Yes, Your Honor.
Mr. Bradfield, I'm sorry, but you either don't hear me or don't care what I'm saying to you. So now you're muted. Okay, so we're going to extend this for 3 months until July the 1st. We're going to have an interim review date of May 19th. Mr. Bradfield, if anything intervening happens that you want the court to take notice of, failure to comply with showing documentation, anything, sir, please keep us posted. And that's as much as the court feels it can do under these circumstances. The motion has been denied for the reasons stated on the record and for the purpose of the record. This court adopts the argument of the people in their response brief in opposition to the defendant's motion. Is there anything else, Ms. Soroki or Ms. Horn?
Yes, Your Honor. With that being said, so what's being required is that he do the level 2 alcohol and safety class as recommended in the sentencing requirements. And I believe the amount that he will owe within 3 months is $695. Is that correct?
Yes, unless he documents to Mr. Bradfield that he does have a limited income. And if that's the case, then the court would entertain any reduction in that or substitution for community service or something other than that. But I can't just waive those fees and costs. They've been imposed in a sentence that was entered by another judge. And so I can't waive those fees and costs. He will have to pay them. And he will have to pay something.
Yes.
I mean, he will have to pay something. I think what has already been imposed is reasonable. But if Mr. Davis can show you that it isn't, Mr. Bradfield, then you bring that to the court's attention with a recommendation. But at this point, the court has found those fees and costs reasonable under these circumstances. We have no documentation, no proof of what Mr. Davis has tried to tell the court today about his limited income. He has indicated that he's already shown that to the probation department and that he doesn't have an issue with showing it again. So if you can document it and Mr. Bradfield, you want to make another recommendation to the court regarding that issue only, then please do so. Is there anything else? Anything else?
Judge, I will share.
Nothing further from the people, Your Honor.
Thank you.
Mr. Davis's probation officer, Officer Williams, I will let her know what has happened today. I was his original probation officer, but this case has been transferred to Officer Williams now, so I will definitely let her know what has transpired today.
Thank you, Mr. Bradfield, and I appreciate your standing in her stead
Thank you, Judge.
for your department. Okay, if there's nothing else, I expect Mr. Davis to be in contact with the probation department and they with him. Do we have accurate information, Madam Clerk, about Mr. Davis's contact information?
Yes, we do, Your Honor.
Okay, if there's nothing further, then this court is going to adjourn. Anything further? And Mr. Davis, I apologize for your having to wait today, but we wanted to make sure we got rid of everything so we could give you undivided attention and hear anything that you wanted us to hear that could be relevant to the court's decision today. All right, sir. I appreciate you. Thank you very much, Madam